My name is Dr. Angela Aslami, and I'm here to testify in support of Senate Bill 1542, an act to protect victims of coercive control. In fact, I'm here to encourage broadening the definition of coercive control by illustrating how it has affected my life. I am a Massachusetts physician, double board certified, and mother of 5. During the 20 years I have been a practicing physician, I have served on state, regional, and national committees on behalf of women's health, and have been trained on domestic violence through courses, lectures, and state-mandated CME requirements. I've provided countless domestic violence resources to my own patients. As a college student, I produced a nationally distributed domestic violence resource catalog through the National Organization for Women. It never occurred to me that I would not be able to recognize domestic violence in my own life. I did not appreciate the fact that domestic violence does not have to be violent or loud, and that it can exist without physical, verbal, or sexual abuse. In other words, it can be sneaky. Many of the examples I will describe are applicable to me, but I will speak more generally. Coercive control is a form of domestic violence. Classic domestic abusers use violence and intimidation. Coercive controllers use virtually every other tactic to control their victims, including financial, legal, social, and technological abuse, counter-parenting, alienation of children, harassment and stalking, and neglectful and/or abusive parenting. Senate Bill 1542 needs to include all of these forms of coercive control, and it is imperative that the family court system be educated regarding coercive control techniques and how the legal system perpetuates victimization. 3 minutes is not enough time to adequately describe all these techniques, so I will highlight a few. Financial abuse can include delaying and refusing payments of child support, alimony, medical bills, therapy bills, and shared expenses. Also, cutting off access to health savings accounts, health insurance, ATM cards, bank accounts, and credit cards, hiding and spending down marital assets, destroying credit scores, quitting jobs and then claiming inability to pay support, and playing the role of financial victim to the children, which causes the kids to question their own worthiness of expenses related to their own basic necessities. Legal abuse can delay divorces for years. This is coercive control and amounts to forced marriage, sanctioned by the state through the family court system's inability to recognize the following tactics: stonewalling, non-compliance with discovery mandates, switching counsel repetitively, refusing all settlement offers, filing frivolous motions, and draining the marital assets on unnecessary legal expenses. The most heartbreaking and shocking abuse, however, is counter-parenting and parental alienation. The end result is that parent-child relationships are severed through a systematic pattern of discreditation, undermining, blame-shifting, triangulation, gaslighting, and rejection of mental health care by refusing to acknowledge, pay for, or participate in the recommended treatments. That is coercive control in the form of child abuse, and there is no greater way to hurt an ex than to hurt their children. I urge you to expand the definition of coercive control within Senate Bill 1542 to include post-separation abuse and the other examples I gave. Again, thank you for your time and your attention to this important issue.